A jury of 12 and 6 alternates was duly impaneled and sworn.
The court said, "Counsel, would you approach, please?"
At the sidebar,
The court said, "Who's opening for the government?"
Mr. Ferguson said, "I am, Your Honor."
The court said, "And for the defense?"
Ms. Shrofa said, "I am."
The court said, "All right. You may step back."
Ms. Shrofa said, "Thank you."
in open court,
The court said, "Good morning."
The juror said, "Good morning."
The court said, "Members of the jury, the case is officially on trial, and you are the jurors in the case. As you can see, the jury is composed of 12 members. In addition, there are 6 alternates. If you are an alternate, you need to pay as close attention to the evidence as the jury. If for any reason any one of the members of the jury is unable to serve, an alternate will be required to step into the place of that juror. I now will give you some preliminary instructions to guide you in your participation in the trial. The second part of the trial is about to start. This part is the opening statement by the prosecution. In the opening statement by the government, he's required to indicate to you what the prosecution intends to prove by way of evidence to support the charges against the defendant. Once the government's opening statement has been completed, defense counsel has the option to make an opening statement. Now, what attorneys say in an opening statement is not evidence. An opening statement is, in a sense, a preview of what the attorney expects that the evidence will show. Next, the government will present a witness and will ask the witness questions. This is called direct examination. Once the government completes those questions, the defense will then be given an opportunity to question the witness. This is called cross-examination. This process will continue for each witness the prosecution will present to give testimony. When the government finishes calling all of its witnesses, the defense will be given the opportunity to present witnesses also. Remember, the defense need not prove anything. Therefore, they do not have to cross-examine the government's witnesses or offer their own witnesses. Once both sides have finished presenting witnesses, the defense and the prosecution will be given the opportunity to make closing remarks to you. These closing arguments will not be evidence. They are just arguments made by the attorneys to discuss the facts and circumstances in the case, and they should be confined to the evidence and to reasonable inferences to be drawn from the evidence. So again, neither opening statements nor closing remarks are evidence, and you should disregard any statement or argument made by the attorney that is not based on the evidence. After closing arguments, I will give you detailed instructions on the law that relates to this particular case. When I finish my instructions, you will then retire to deliberate to reach a verdict. Now I'm going to instruct you on evidence. First, let me tell you what evidence is. Basically, evidence consists of oral testimony under oath, any stipulations of the parties, and physical exhibits during the trial that are introduced by either the prosecution or the defense and allowed into evidence. If an exhibit is given to you to examine, you should examine it carefully, individually, and without comment. There are 2 types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact such as testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. There's a simple example of circumstantial evidence that is often used in this courthouse. Assume that when you came into the courthouse this morning, the sun was shining and it was a nice day. Assume that the courtroom shades were down and you could not look outside. As you were sitting here, someone walked in with an umbrella that was dripping wet. Then a few minutes later, another person also entered with a wet umbrella. Now you cannot look outside the courtroom and you cannot see whether or not it is raining, so you have no direct evidence of that fact, but on the combination of facts that I have asked you to assume, it would be reasonable and logical for you to conclude that it had been raining. That is all there is to circumstantial evidence. You infer, on the basis of reason and experience and common sense, from one established fact the existence or non-existence of some other fact. Not all circumstantial evidence presents clear, compelling inference. The strength of the inferences arising from circumstantial evidence is for you to decide. I will give you further instructions on these as well as other matters at the end of the case, but have in mind that you may consider both kinds of evidence. If you're instructed that some evidence is received for a limited purpose only, You must follow that instruction. Questions asked by either attorney or even myself are not in and of themselves evidence. Only questions coupled with answers are evidence. Therefore, you may not infer any fact from the mere asking of a question. The reason that I point this out to you is simple. During the course of questioning, the prosecution and the defense may exercise their right to object to the other's question, to an answer given to a question, or to introduction of an exhibit on the ground that the attorney believes it is somehow legally improper or inadmissible. At that point, I will sustain or overrule the objection. If I sustain an objection to a question, you must disregard the question and any answer, if one has been given. You must also draw no inference from the question or from any answer. Nor are you to speculate as to what the witness would have said if permitted to answer. Evidence stricken from the record must likewise be disregarded. Conversely, if I overrule the objection, the question will be allowed and the answer will stand, and it remains as evidence. When I overrule an objection to any evidence, you must not give such evidence any more weight than if the objection had not been made. Please bear in mind that my rulings on the law are simply that, and under no circumstance are such rulings to be considered by you as indicating that I have any opinion as to the guilt or innocence of the defendant. Under our law, the judge may not and will not entertain any opinion as to the guilt or innocence of the accused. Members of the jury, you and you alone are the sole and exclusive judges of the facts. Now I want you to understand that objections may come rather quickly, and at times either party may seem worried. Please do not resent this or penalize either party for this. Understand that they are just doing their job and this is part of it. As I stated at the beginning, you are the triers of fact. Therefore, it is up to you to decide which witness to believe and which witness not to believe. Furthermore, you will decide how much of every witness's testimony to accept and how much to reject. How do you decide what to believe and what not to believe? Listen to the witnesses, watch them, and observe them. Then decide whether you believe or disbelieve them in the same way that you decide such questions in your everyday life. Did they know what they were talking about? Were they candid, honest, open, and truthful? Do they have a reason to falsify, exaggerate, or distort their testimony? Just use your common sense in evaluating all testimony. All that is asked of you is that you apply the same common sense you would apply in your everyday lives to determine who is telling you the truth, who is not, and who is telling you something less than the full truth. Please remember that it is the quality of the evidence that controls, not the quantity of the evidence, or the number of witnesses called by either side. You must decide the case solely on the evidence and law before you, and must not be influenced by any personal likes or dislikes, opinions, prejudices, sympathy, or biases, including unconscious bias. Unconscious or implicit biases are stereotypes, attitudes, or preferences that people may consciously reject but which may be expressed without conscious awareness, control, or intention. Like conscious bias, unconscious bias too can affect how we evaluate information to make decisions. All of us, no matter how hard we try, tend to look at others and tend to weigh what they have to say through the lens of our own experience and background. We each have a tendency to stereotype others and to make assumptions about them. Often we see lights and evaluate evidence through a clouded filter that tends to favor those like ourselves. You must do your best to put aside such stereotypes, for all litigants and witnesses are entitled to a level playing field, in which we do the best that we can to put aside stereotypes and prejudices. You are to be guided solely by the evidence in the case and my instructions on the law. Although you are the sole judges of the facts, my job is to be the sole judge of the law. You must accept the law as I give it to you, without any hesitation or reservation. You must accept the law as I give it even if you privately disagree with me or the law. There are three basic principles of law that apply to this in all criminal cases: the presumption of innocence, the prosecution's burden, and the standard of proof. First, the presumption of innocence. A defendant is presumed innocent, and that presumption remains with the defendant throughout the trial, and is not removed unless and until the defendant's guilt is proven beyond a reasonable doubt. The indictment containing the charges against the defendant is only an accusation, nothing more. It is not proof of guilt or anything else. Therefore, because no evidence has been presented to you as of yet, if you were to deliberate right now, you would have to find the defendant not guilty. Second is the prosecution's burden. The burden of proof is on the government. The defense has no burden and is not required to do anything to prove his innocence. The defense has the option of just sitting back and doing nothing. Why? Because the defense has no burden of proof, and the defendant is presumed innocent. The defendant is not required to put on a defense or call any witnesses because of the presumption of innocence. If the defendant chooses not to take the stand, to testify on his behalf, you may not draw any negative inference from that. In other words, you cannot hold that against the defendant. Third is the standard of proof. The prosecution is required to prove the defendant's guilt beyond a reasonable doubt. This standard does not require the prosecution to prove the defendant's guilt beyond all doubt or to a mathematical certainty. The prosecution does, however, have to prove the defendant's guilt beyond a reasonable doubt. The doubt is not reasonable if, instead of being based on the nature and quality of the evidence or the insufficiency of the evidence, it is based on some guess or whim or speculation unrelated to the evidence. In my final instructions to you at the end of the trial, I will give you detailed instructions on the law as to the specific charges against the defendant. Those instructions are intended to guide you through your deliberations and to enable you to reach your decision. Finally, I'm now going to instruct you on how you must conduct yourselves during the trial. You must keep an open mind during the trial. You must keep your eyes open during the trial. You may not ask the witnesses questions. Do not converse either amongst yourselves or with anyone else about anything related to the case. You may tell the people with whom you live and your employer that you are a juror and give them information about when you'll be required to be in court. But you may not talk with them or anyone else about anything related to the case. Do not at any time during the trial request, accept, agree to accept, or discuss with any person the receipt or acceptance of any payment or benefit in return for supplying information about the trial. You must promptly report directly to me any incident within your knowledge involving an attempt by any person to improperly influence you or any other member of the jury. Do not visit or view the premises or place where the charged crimes were allegedly committed, or any other premises or place involved in the case. And you may not use Internet Maps or Google Earth or any other program or device to search for and view any location stated in the testimony. Do not read, view, or listen to any accounts or discussions of the case reported by newspapers, television, radio, the Internet, social media, or any other form of news media. Do not attempt to research any fact, issue, or law related to this case, whether by discussion with others, by research in a library, or on the Internet, or by any other means or source. In this age of instant electronic communication and research, I want to emphasize that in addition to not conversing face-to-face with anyone about the case, you must not communicate with anyone about the case by any other means, including by telephone, text messages, email, Internet chat or chat rooms, blogs, or social websites such as Facebook and X. You must not provide any information about the case to anyone by any means whatsoever, and that includes the posting of information about the case or what you are doing in the case, on any device or Internet site, including blogs, chat rooms, social websites, or any other means. You must also not Google or otherwise search for any information about the case or the law that applies to the case or the people involved in the case, including the defendant, the witnesses, the lawyers, and myself. Now, ladies and gentlemen, I want you to understand why these rules are so important. Our law does not permit jurors to converse with anyone else about the case or for anyone to talk to them about the case because only jurors are authorized to render a verdict. Only you have been found to be fair, and only you have promised to be fair. No one else has been so qualified. Our law also does not permit jurors to converse among themselves about the case until the judge tells them to begin deliberations, because premature discussion can lead to a premature final decision. Our law also does not permit you to visit a place discussed in the testimony. First, you cannot always be sure that the place is in the same condition as it was on the day in question. Second, even if it were in the same condition, once you go to a place discussed in the testimony to evaluate the evidence in light of what you see, you become a witness, not a juror. As a witness, you may now have an erroneous view of the scene that may not be subject to correction by either party. That is not fair. Finally, our law requires that you not read or listen to any news accounts of the case and that you not attempt to research any fact, issue or law related to the case. Your decision must be based solely on the testimony and other evidence presented in the courtroom. It would not be fair to the parties for you to base your decision on some reporter's view or opinion, or upon information you acquire outside of the courtroom. These rules are designed to help guarantee a fair trial, and our law accordingly sets forth serious consequences if the rules are not followed. I trust you understand and appreciate the importance of following the rules, and in accord with your oath and promise, I know you will do so. During the trial, it may be necessary for me to confer with the lawyers out of your hearing with regard to questions of law or procedure. On some occasions you may be excused from the courtroom for that reason. I will try to limit these interruptions as much as possible, but you should remember the importance of the matter you are here to determine, and should be patient even though the case may seem to go slowly. Finally, I permit jurors to take notes, but you do not have to take notes. Notes are just an aid in your own recollection. The court reporters in this case record everything that is said in the courtroom, and any portion of the testimony can be read back to you here in open court during your deliberations. If you do take notes, be aware that note-taking might distract you from something important that is happening on the witness stand. Whether or not you take notes, rely on your own recollection, and don't be influenced by the fact that another juror has taken notes. I just told you that you are to report any attempt by anyone to improperly influence you. Lawyers are not permitted to have any contact with you other than what takes place on the record in this courtroom. If you see an attorney, for an example, in the hallway or outside, and the attorney does not say hello or acknowledge your presence, please don't think that the attorney is being rude. The attorneys simply are not permitted to have that type of contact with you. Now Assistant United States Attorney Micah Ferguson will make his opening statement.
Mr. Ferguson said, "This case is about how the defendant, Miles Guo, conned thousands of investors out of $1 billion. And it's about how he spent millions of dollars of victim money on himself. In online videos, the defendant pitched investments in a series of companies. In these videos, the defendant said many false and misleading things. But at its core, the defendant's fraud was simple. He promised his victims they'd get rich, that their investments were safe, and they would not lose any money. He told them that, as an ultra-rich billionaire, he would personally guarantee and pay back any losses. He assured them he would never, ever let their investments be stolen. These were lies. The truth is that the defendant took investor money and spent it on himself: million-dollar cars, yachts, a mansion. Miles Guo ran a simple con on a grand scale. He lived a billionaire's lifestyle using money he stole from people he tricked and cheated. Now the defendant couldn't run a con this size alone. You'll learn that the defendant and his partners in crime built a criminal enterprise of different companies to carry out this fraud. Some of the companies had offices right here in New York City. The employees called the defendant the boss and the principal. And the defendant and his inner circle used these businesses to steal money from their victims and to spend it on themselves. And that's why we're here today, because when the defendant conned people out of their money, he committed several crimes involving fraud. When he and his partners moved around investor money to hide that they were spending it on themselves, they committed money laundering crimes. And because the defendant committed these crimes, using a criminal enterprise, a group of people and companies he controlled, he committed a racketeering offense, a RICO conspiracy. Ladies and gentlemen, in this opening statement, I'm going to tell you what the evidence at this trial will show and how the government is going to prove beyond a reasonable doubt that the defendant is guilty. So first, what will the evidence show? For years the defendant deceived thousands of people and stole their money to pay for a lifestyle he could no longer afford. You see, the defendant used to be a wealthy real estate developer in China. But he left China and came to the United States. Eventually the defendant spoke out against China's government, the Chinese Communist Party, or the CCP for short. He began giving interviews and broadcasting his own videos. And he didn't talk just about the CCP. The defendant also talked about how rich he was. He showed off his $70 million apartment on Central Park, or his $30 million yacht. And the defendant's mix of showing off wealth and criticizing the CCP was popular. He became an internet celebrity in the Chinese community. He had thousands of followers. And you're going to learn that the CCP didn't like this, that the CCP tried to silence the defendant. Even tried to have him brought back to China. And you'll learn that the governments of China and Hong Kong seized the defendant's assets shortly before the schemes began. So the defendant needed money. Now you're going to learn that the defendant pitched many different investment schemes to his victims. But each one was just a new spin on the same simple fraud. The defendant told his followers that their money would be used for an investment, and they could not lose any money. And instead, the defendant stole the victim's money and spent it on himself. He did that through four main schemes: GTV, the farm loans, G-Clubs, and the Himalaya Exchange. I'm going to talk about each of those schemes in turn. So the first business that the defendant raised money for was GTV. What was GTV? It was an online media company with a website and an app that had the defendant's videos, his broadcasts on it. What did the defendant tell his followers about GTV? He told them it was their special opportunity to get rich without any risk. In 2020, the defendant announced in his online broadcast that he would let his followers buy GTV stock. The defendant told his followers that investing in GTV had no risk. He told them he would personally pay back any losses. He told them that investing in GTV could only make them money. These were lies. And the defendant even lied about the most basic part of the GTV investment, that the money raised from GTV investors would be used for GTV. To grow the business of GTV. Even that basic promise was a lie. But the defendant's followers trusted him. And money poured in. In months, victims invested over $400 million in GTV. What did the defendant actually do with that money? Almost immediately, just days after the fundraising for GTV closed, the defendant took $100 million of GTV investor money and used it for a high-risk investment on behalf of his son. He essentially made a bet using $100 million of GTV investor money. Sent it to a hedge fund for an extremely risky investment. This bet wasn't even made on behalf of GTV. It was made in the name of a company owned by the defendant's son. And guess what? The hedge fund bet didn't pay out. This hedge fund bet lost $30 million. The defendant told GTV investors that he would personally guarantee their money and pay back any losses. Did he pay back the $30 million loss? No. That was just a lie. What was GTV? It was one way that Miles Guo lied to take other people's money. But it wasn't the only way. There's GTV and then the farm loan scheme. Now farms. These farms didn't have anything to do with farming or agriculture. The defendant used the word farms to refer to online groups of his followers in different cities or countries. And the farm loan scheme was just a way to continue the GTV scheme. You see, almost right away, U.S. regulators began investigating what GTV was doing. Funds were frozen, and GTV's bank accounts were shut down. But the defendant, he didn't stop. Instead, in his broadcasts, the defendant blamed these problems on the Chinese government. He claimed that victims who were complaining about their money being stolen were traitors and CCP spies. And the defendant told his followers they could still buy GTV stock, they just couldn't call it stock. Instead, investors could use loans that would be organized through the farms. You see, each farm opened bank accounts that were used to collect and pool money from farm members, the investors. The defendant told his followers that to get GTV stock, they could enter a loan agreement with a farm and send their money to that farm. He said the farm would then enter a loan agreement with GTV, and after a few years, the defendant's followers, the farm members, could choose whether to get GTV stock or cash. But that was another lie. The defendant and his money launderer stole the farm loan money for themselves, and the victims got nothing. GTV. Then the farm loan scheme. What were the farm loans? They were another way that Miles Guo lied to take other people's money. The next scam was G-Clubs. Now G Clubs was supposedly a high-end lifestyle membership club, but really, it was another way for the defendant to sell stock without calling it stock. The defendant told his followers that by paying G Club's initial membership fee, they would get stock in GTV or G Fashion, the defendant's clothing company. How much was the initial membership fee? The initial fee started at $10,000 and went up to $50,000 on the high end. Thousands of the defendant's followers paid this fee, sending G Clubs hundreds of millions of dollars and expecting to receive stock in return. But G Club's members did not get stock. That was another lie. Did members get anything for their membership costing tens of thousands of dollars? The main thing they got was a discount at G Fashion, which sold expensive clothing to the defendant's followers. Like an $800 pair of sweatpants. You could get 10% off that price if you paid $10,000 for a G Club's membership. And while G Club's members did not get stock or any benefit worth tens of thousands of dollars, the defendant spent the G Club's membership money on himself and his family. GTV, farm loans, G Clubs. What was G Clubs? It was another way that Miles Guo lied to take other people's money. Now the defendant didn't just pitch stock to his followers. He also pitched a pair of cryptocurrencies sold on the Himalaya exchange. At first he called them G-Coin and G-Dollar. Then they became H-Coin and H-Dollar, H-Coin for Himalaya Coin, H-Dollar for Himalaya Dollar. These cryptocurrencies were another scam. In his broadcast, the defendant told his typical lies about this cryptocurrency, guaranteeing investors would not lose money. He told his followers that H-Coin was backed 20% by gold. Ladies and gentlemen, H-Coin was not backed by gold. The defendant tricked his followers into buying H-Coin and H-Dollar because he wanted more money. You see? The only place you could buy H-Coin or H-Dollar was a supposed cryptocurrency exchange called the Himalaya Exchange. But the Himalaya Exchange was run by the defendant's money launderer. Same one who helped him steal the farm loan money. You're going to learn that when the defendant was in a bind and needed money, the defendant's money launderer sent $37 million of Himalaya Exchange money, real dollars, not H-Dollars, to get the defendant out of the bind he was in. $37 million of money that victims sent to the Himalaya Exchange used for his benefit. GTV, farm loans, G Clubs. The Himalaya Exchange. What was the Himalaya Exchange? It was one more way that Miles Guo lied to take other people's money. These four schemes were really just different versions of the same con, where the defendant tricked people out of their money so he could spend it on himself and his family. And he did it for greed. He used investor money to pay for a luxury yacht, for private jets, to buy luxury cars. A Lamborghini that cost nearly $1 million, a Bugatti that cost $4 million, a $4 million Ferrari for his son. A second luxury yacht, a 50,000 square foot mansion that he paid millions more to renovate for himself and his family. And to buy things like a $35,000 mattress and a $60,000 TV. And the victims? The investors whose funds were stolen by the defendant to fund these spending sprees? They got nothing. They just lost money, money they had saved, money they had borrowed, their family money, money they thought was safe. And he just stole it.
Ms. Strofa said, Your Honor, objection.
The court said, overruled.
Ms. Strofa said, This is opening statement.
The court said, overruled.
Mr. Ferguson said, That's what the evidence is going to show. Now how is the government going to prove it? Prove to you that the defendant is guilty? You're going to see and hear several different types of evidence. You will hear the defendant's own words. You will see the defendant lie on video over and over. You'll see him lie and say that his victims can't lose money, that he would pay back any losses, that he would never spend investor money on himself. And you'll hear him lie about what he did with investor money, saying that he has not touched even a penny of it, and admitting that if he did, it would be a crime. You'll also hear what the defendant and his co-conspirators said on phone calls when they didn't know they were being recorded by a concerned employee. You will hear the defendant order his co-conspirators to transfer $100 million of investor money that he later used to buy his mansion. And you're going to see records related to each of the four main frauds. About how the investor money was supposed to be used, and then you'll see records showing how it was actually used. Bank records showing how the defendant and his co-conspirators used dozens of shell companies and hundreds of bank accounts to conceal the fact they were spending investor money on themselves. You'll see the GTV investment document that says GTV investor money would be used to grow GTV's business. And then you'll see the record showing $100 million of GTV investor money going instead to a hedge fund bet for the defendant's son. You'll see the farm loan contracts given to victims, pieces of paper that were ultimately worth nothing to them. You'll see the bank records showing that farm loan money was just stolen. And you'll see photographs of the things the defendant bought with G Club's membership money. All while promising in his recorded broadcast that G Club's memberships were a way to invest in GTV or G Fashion. You'll see photographs of the G Club's Lamborghini that was parked in the defendant's garage at his Connecticut home. Photographs of the defendant's mansion in New Jersey, paid for with G Club's money. You'll see photographs of the defendant's custom Italian suits hanging in his bedroom closet at that mansion. You'll see the bank records showing the $37 million transfer of Himalaya exchange money for the defendant's personal benefit. All while the defendant told investors in recorded broadcasts that he had no ownership in the Himalaya exchange and that H-coin and H-dollar money was secure. Now you'll also hear the testimony of witnesses. You will hear from people who used to work for and used to trust the defendant. You'll hear from former employees of the defendant's G businesses. They will tell you that the defendant and his co-conspirators ran and controlled those businesses and made the decisions about how money was spent and where it was transferred. Now some of these former employees are testifying pursuant to what's called non-prosecution agreements, in which the government has agreed not to prosecute them in exchange for their testifying at this trial. So you should listen carefully to the testimony of these witnesses. When you do, you'll see it's consistent with all the other evidence in the case. Ladies and gentlemen, you will also hear from victims of the defendant's fraud, people who were drawn into Miles Guo's online world. People who trusted Miles Guo, who believed the lies he told them, and who lost money, sometimes their life savings. As a result, people who eventually realized they were being scammed. Now the evidence. It's not going to come in all at once. You'll see it witness by witness, document by document, one piece at a time. But at the end of this trial, after you've heard the testimony and you've seen the evidence, you will see the full picture. This man conned thousands of investors and stole $1 billion. At the end of the trial, we'll have a chance to speak with you again. Between now and then, I'm going to ask you just to do three things. First, pay close attention to the evidence. Second, follow Judge Torres's instructions on the law. And third, use your common sense, the same common sense and good judgment that you use every day in your lives as New Yorkers. If you do those three things, you will reach the only verdict that is consistent with the evidence and the law. The defendant is guilty.
The court said, "Now we will have the opening statement on behalf of the defendant, Mr. Guo, by Ms. Sabrina Shroff."
Ms. Shrofa said, "Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. It was not a bet. It was not a scheme. It was not a con. It was none of those things. And the reason we are here today is not because the government brought an indictment. The reason we are here today is because Mr. Guo has pleaded not guilty to the indictment. And the evidence in this case will show all of the evidence, the witnesses that they bring in. As government counsel noted, one by one, the documents that come in one by one will lead you to only one conclusion. And the conclusion is that Mr. Guo is not guilty of the 12 counts brought in this indictment. I am here to tell you why there is no conspiracy, RICO or otherwise, and there is no enterprise. Mr. Guo is not guilty of the charges in this indictment. Before I do that, and before I speak more to what the evidence will show in this case, please allow me to introduce myself. My name is Sabrina Shroff, and I, along with my colleagues, represent Miles Guo. Miles Guo is one of 8 children who started life with very little, born and raised in China. And that is in fact where he and his brothers and his family made a fortune in real estate. The evidence in this case will show that the fortune was humongous. And yes, the government would like you to draw many negative inferences from a person who, according to them, spent thousands of dollars on a TV or on a mattress. I ask you please, when you consider the evidence, consider the evidence within the context and not to be drawn in by the government's invitation to make judgment calls about people who have money and spend it in a way that you and I simply wouldn't. So let's talk about what the evidence in this case will show. The evidence in this case will show how Miles Guo, filled with a determination to accomplish a goal, he had a goal, and how he worked on that goal over a period of years. And the goal was to establish, to set up, to form, and to move forward a movement that would allow the people of China, the Chinese people, to know that there was an alternative to the Chinese Communist Party. And how the Chinese Communist Party could be removed so that everybody could live in a way that they chose to live. Mr. Guo, the evidence will show, did not have criminal intent, and when the evidence in this case is complete, you will see that what the government is trying to string together is not just a group of people to try and prove to you an existence of a conspiracy that really doesn't exist, but also asking you to make value judgments about how money is made and how money is spent. So let me start where the government had started. Let me talk about what the government spent the majority of the time today, and what the government will spend a majority of the time throughout this case on. The one person they ask you to convict, Miles Guo. He was raised in China, one of 8 boys. And each one of them grew up from nothing and made a fortune in real estate. The real estate fortune of the 8 brothers in China was not just worth millions. It was worth hundreds and hundreds of millions of dollars. And you will hear that despite this incredible success, financial fortune that he had in China, Mr. Guo left China and came eventually and settled down in New York. And you will ask yourself, and the evidence will show why Mr. Guo left China. He left China because he'd taken on the CCP, the Chinese Communist Party, and they were not pleased with him at all. The Chinese Communist Party also had a goal, and they were very determined to make sure their goal was met. Their goal was to make sure Miles Guo stopped speaking about the CCP. Now you've heard from government counsel earlier today, and he has certainly invited you to make moral judgments, value judgments, all sorts of judgments, but what he has asked you to do at his core, he's asked you to receive from him almost a fiat that Mr. Guo lied. He wants you to accept that Mr. Guo lied so that people would give him money, and then wants you to accept that the only thing he did with that money is spent it on himself and his family. That is not this case, and that is not true. You are going to hear that, like almost every one of us. There's more than one aspect to Miles Guo, and some of the aspects and some of the things you will hear during the testimony in this case will be both surprising and eye-opening. So when you evaluate the evidence that comes in through the witnesses, when you think about Miles Guo's story, when you think about who Miles Guo is, I ask you, keep in mind and conceptualize the world that he lived in, because it is not our world. Our world is not filled with surveillance, constant harassment, and constant oversight and disruption by the Chinese Communist Party. You will hear testimony in this case from government witnesses that Mr. Guo was forced to leave China. He was forced to leave behind his wife and his daughter. Both were arrested and detained in prisons in China for almost 2 years. You will learn and you will have evidence that shows you that once Mr. Guo got to New York, instead of focusing on all the negatives that were before him and all the hurdles he had to face, what he did is, he started to and continued over time to speak out against the Chinese Communist Party. And that is what he did all the time, all day long. That was his goal, to get that story out. And repeatedly he said, and you will hear it through the trial, that the people of China are not the Communist Party. That is what he wanted to tell the people that were here in the United States, and the good-thinking people that he had to leave behind in China. What is it that he set out to do? He set out to start a movement and tell the truth about the CCP. And with that, he started to speak, he started to write, and he started to broadcast. And soon that came to be known amongst those who believed him and amongst those who followed him to be the whistleblower movement. And what did he talk about? He talked about things that he knew. He knew of the corruption in the CCP. And that's what he talked about. He knew certain secrets of corrupt government officials. And that's what he talked about, specifically. What else did he know? He knew the many ways in which the CCP worked. And he knew of the many ways that the CCP could make one's life hell. And one's professional life, and one's business life, and one's personal life. Now once Mr. Guo started talking about the CCP, the reaction to it was immediate and strong. And the reaction wasn't just from the people who were enthralled by what he had to say. There was another reaction too. There was a reaction by the CCP, the Chinese Communist Party. And they too had a goal. Their goal was to make sure that he stopped. So you see that most vividly when Mr. Guo, and the evidence will show, had a broadcast on April of 2017, April 19th of 2017, when he starts and gives a live interview on Voice of America. In face of relentless bullying by the CCP to stop, to be quiet, Mr. Guo decided to have a live feed interview on April 19th. The interview was, and his goal was, to broadcast in an uncensored, live manner so that nobody could doctor what he had to say. And what happened to this live interview? While he's still speaking in mid-speech, the feed is cut off. The line is cut off, and the interview is stopped. There is no warning. There is no notice. All of a sudden, all of the work he had put in to make sure this interview goes through, it's cut off. And what happens after that? What happens after that also gives you a context about the world in which Mr. Guo has to live and do business. Immediately after the April 19th interview, the Chinese Communist Party issues what is called a red notice. That is, a red notice is a warrant through the Interpol, seeking Mr. Guo's immediate arrest and extradition back to China. After that interview with Voice of America, his wife and his daughter are arrested in China by the Chinese police. He loses all access to social media. His YouTube account is cut off. His Twitter is cut off. And he has no access whatsoever to any methodology by which he can get his word out. What else do they cut off access to? They cut off access to any method by which he could get himself or his businesses any help. The CCP hacked his phones. Every cell phone he has, they hacked. They hacked his computers, his home computers, and his work computers. They even hacked the home and work computers of other people who are either assisting him or doing business with him. And this pattern of harassment by the CCP, and the evidence will show all of this pattern, escalates and becomes more and more sophisticated. So let me give you an example of how sophisticated this harassment can get. At one point, the CCP is so determined to shut down any and every bank account that the CCP starts to send money into these accounts in the names of people who are on the OFAC list. The OFAC list is a list set by the United States government that lists the names of people who have engaged in criminal conduct and are not allowed to use our banking system. The CCP uses those names to send in money, triggers a reaction from the compliance people in the bank. The bank shuts down all of his accounts because the monies being wired, they think, are in the name of known criminals on the OFAC list. You will hear all of this evidence from the government witnesses. And you will know that the CCP has 1,000 different ways to mess with Miles Guo and to try and stop the political movement that was really the essence of his entire being. The evidence will show why Mr. Guo continued in this movement, and why he endeavored to overcome each and every one of these hurdles. He was determined to make sure the movement survived. And he wanted to make sure others who wanted to join the movement were able to do so. So what did Mr. Guo do? He set up the Rule of Law Foundation and he set up the Rule of Law Society. He dedicated both those entities to make sure that they provided people with support to fight the propaganda given by the CCP. To give voice to the movement, he created a social media company. The government lawyer has spoken endlessly about it. GTV. What was GTV? GTV was a real company set up to spread the message of the whistleblower movement. The point of GTV was to get an uncensored voice out, not to just the people of Chinese beliefs and systems who lived in the United States, but also the many people who were left behind in China who also wanted to be part of that movement. And that is what GTV offered them. Yes, GTV was the first of multiple business opportunities that aimed to spread the voice of the whistleblower movement. Mr. Guo participated in GTV, the Farm Loan Program, G-Clubs, and the Himalaya Exchange and its currencies, H-Coin and H-Dollar. These businesses were at the heart of the movement, and the government is simply wrong when it argues that they were not real businesses. The evidence in this trial will show that GTV was, unlike many others, a citizen-based journalism website. It allowed for people to speak openly and talk to each other without repercussions from the CCP. The Farm Loan Program. The Farm Loan Program, the evidence will show, not what this prosecutor has just told you, but it will show that the Farm Loan Program was a way for people to give their money at an interest rate to support the movement that they were interested in. And it was a way for people to earn money from these loans. I remind you, keep an eye on the time frame when all of this happened. United States and most of the world is in the midst of a pandemic, and people are eager to interact with each other online. What was G-Clubs? G-Clubs was what the government lawyer here mocks whether or not one should spend X amount of dollars on a sweatshirt or sweatpants. I think he said sweatpants. That is a person's choice. And that is exactly what China didn't want people to have and what the movement did want people to have, choice. You want to spend your money that way, that is entirely up to you. And what did G-Club's membership allow? It allowed a person, if they wanted, to support the movement at whatever price they wanted to support it. If you wanted to support it at the $10,000 level, you could, and if you wanted to support it at the $50,000 level, you could. The evidence will show, and I ask you, when the evidence comes in, do not take that invitation to make a moral or value judgment on what and how people should spend their money. The question is, does the evidence show the existence of real companies, the existence of real employees, the existence of people who did actual, real good work, the existence of people who dealt with the same problems you and I deal with at our jobs, trying to do the best job we can because we're chosen by people and bosses, because we have talent, expertise, and hard work, and those are the people that worked in each one of these companies. There is no denying at all that all of these entities were built around Mr. Guo's celebrity. Yes, and he was the one who started speaking as early as 2017 and continued speaking against the CCP. You know what else the evidence will show? That not just other people were the ones who invested. Mr. Guo's friends invested, Mr. Guo's family members invested. Why? Because they too believed in the movement. So they invested. They invested in GTV, they invested in the farm, they invested in G-Clubs. And they invested on the Himalaya Exchange. They believed. The evidence will show that these companies were built, were put together, just like any other business, maybe not with the same level of infrastructure, but people believed. And Mr. Guo, like many of us, had a vision, had an idea. What he did not quite have is the infrastructure that you and I bring to our daily lives. When he first started, he spoke very little or no English. He was new to this country. He wasn't familiar with the way things are done. And yes, you will hear recordings in which he speaks in a demanding voice, one instant, for work to get completed. And at sometimes even appears to be extremely pig-headed in a way that many a person is. Does that mean he's a criminal? No. Does that mean he committed these crimes? The evidence will show it does not. What the evidence, again, will show is that the people who he hired were people who were able to contribute to each one of these businesses. Now the government, I suppose, will spend some amount of time introducing evidence about two individuals, Yvette Wang and William J. And I ask you, as you hear the evidence the government puts in, to pay some and close attention to what roles each one of these people played. The testimony will show that Ms. Wang was the head of operations. She ran the day-to-day of each business. She was in charge of hiring. She did the best to hire people. And her hiring practices were the same as yours or mine. She hired people that she met along the way in her business. She hired people through a headhunter when she needed a person or a spot filled. And she was no more or no less committed and no more or no less demanding than any other chief executive officer that works. William J. is another name that the evidence will show, and William J. was the finance guy. He's a well-regarded investment banker who had managed the fortune not just of the Guo family fund, but he had managed the fortunes of many other companies. He had expertise, he had skill, and that is why he was the finance guy. And I've already talked at length about Mr. Guo, who was the ideas man. He came up with the ideas, and he put together the thought and the vision of what the movement that he believed in would look like. So you see, he wasn't alone in the movement. He wasn't moving all on his own. In fact, that's why it was called the whistleblower movement. The point of it was to have others join and participate. So what will the evidence show at the end of the day? The evidence will show that each one of these companies hired and had people working towards the existence of a real business. They believed, and Mr. Guo believed. Mr. Guo believed in this movement. So when the government lawyer asks you and tells you to believe that Mr. Guo defrauded the members of this movement, what the government is saying to you is that he intentionally misled supporters to steal money. The same money that they had given to the movement that he had devoted almost his entire life to. The movement for which he fled China, the movement for which he put up with being followed every day, the movement for which his phones were hacked, the movement for which his wife and his daughter sat in prison for 2 years, and the movement for which he was not allowed to leave and travel outside the United States, the movement for which he risked his very existence. That's what they're saying he set out to harm. They're saying that he set out to harm the very thing that was almost an extension, a symbiotic extension of who he was. And he did all of that, even though he had a fortune from a family fund that allowed him to live in luxury. What the government is asking you to believe is not just illogical, it defies common sense. I ask you to consider this. All of the evidence that the government lawyer talked about, the wealth, the millions of dollars worth of luxury hotel in Manhattan where he lived, the yacht, the mattress, whatever it is that he talked about, you know what the evidence is going to show. The evidence is going to show that no matter what else these witnesses say to you, Mr. Guo had that lifestyle long before the government even alleges that he committed this fraud. The suits, sweatpants, the house, the evidence will clearly show that has been his lifestyle for decades. Well before the government says he lost money and well before any of this was even a thought in the government's mind. And it certainly continues today and continued for days after because the family fund will always support Mr. Guo. And I ask you to consider this, because the government does invite you to make this value judgment. It is easy for a person to judge another as either shallow or rich, but shallow or rich does not make for a criminal. That does not mean that the government's inference is a proper one. The evidence will clearly show that Mr. Guo did not need to steal money to buy the Brioni suits. None of that would be worth all of the hardship he went through to keep the CCP at bay. What the evidence will show here is that Mr. Guo did not steal money from GV. He did not steal money from the farm loans program, he did not steal money from G clubs, and he did not steal money from the Himalaya exchange. The government will also invite you to think and invite you to conclude that the reason Mr. Guo did certain things are because he was engaged in criminal activity.
Continued on next page.
Ms. Schrofa said, so what else is the government going to elicit in terms of evidence? The government is going to seek to elicit that Mr. Guo had constant telephones that he changed. He had almost hundreds and hundreds of telephones. And that he had these telephones. And he changed his number constantly because he didn't want people to know what he was doing. I ask you to consider this. If you have been the target of constant hacking by the CCP, and if you have been the target of people listening in on your phones, using your voice recordings to impersonate you, wouldn't you also change your phones that often? If you were in constant fear of being threatened, kidnapped, killed, moved, would you also not have a car that does not tell people where and when you're going to be taken? It's logical that that is what a person who is being surveilled would live in that manner. If you were Mr. Guo and you were being constantly targeted, wouldn't you want a safe and secure place to have business meetings? Wouldn't you establish a base where people you wanted to do business with could come and meet with you without the interference and the distortion from the CCP? For every piece of evidence of wealth that they put in, you will have an equally fair inference that he took those steps not to cheat, not to indulge, but to make sure that the movement survived despite the distortions of the CCP. I ask you to keep in mind when they talk to you about bank accounts, MAWA, homes, ask yourself, why would a person have to open a bank account unless, of course, each time a bank account was owned, somebody from the OFAC list deposited money into your account and had compliance to them? That's the reason why Mr. Guo's actions must be evaluated in the context and the lifestyle in which he was supposed to exist. So the government will introduce the evidence. And I ask you to keep in mind that for each piece of evidence that comes into them, the necessary inference from them is not the accurate one. They ask you to infer from the filing of a bankruptcy that Mr. Guo simply did not have money. Now, whether we think it's fair or whether we think it unfair, the rich often declare bankruptcy. Personal bankruptcy does not mean poverty. None of that inference is correct. And I ask you, when you hear evidence of that, to consider how it is that Mr. Guo, who did not have any personal assets at that time, because the CCP was the one that had seized his property. There was a time, and you will hear evidence coming in, that Mr. Guo was to pay a fine of almost $100 million within a few days. And that is what leads to a filing of bankruptcy. But the government's request that from that you draw the conclusion of guilt, again, is a misplaced request. The government will argue throughout this case that what Mr. Guo did was simply unlawful. They will ask you to say you can be persecuted and you can still be a fraud. And when they ask you that, I ask you to think about how the evidence shows them to be wrong. The government isn't just saying that there is a fraud. What the government is asking you to do is to conclude that Mr. Guo defrauded essentially himself because he is the movement, and the movement him. So when they ask you to take a look at the evidence that comes in, the evidence of wealth, the evidence of spending, the evidence of luxury, I ask you to evaluate all of that evidence in the context which I have described. And if you do so, and if you evaluate the evidence, understanding how difficult it was for these entities to survive, and how each one of the people who worked for these entities worked hard to maintain and forward a movement, you will reach the only logical conclusion in this case, that Mr. Guo is not guilty of the 12 counts of the indictment. Thank you.
The court said, members of the jury, I want to remind you about our trial schedule. Every day, every weekday, you'll be entering the courtroom at 9:30 in the morning. By 9 o'clock, you'll have a light breakfast available to you, so you can come early. But you must be ready to enter the courtroom at 9:30. So in general, we'll take a half-hour break between 11:30 and 12, and I will also have a light lunch for you. And then we'll go until 2:45. By condensing the schedule this way, I don't take up your entire day until 5 p.m. I'm very aware that you have other important things to do during the day, and so that is why I've designed the schedule in this way. So at this time we will take our half of an hour break.
Jury not present.
The court said, you may be seated. Counsel, is there anything before we return in half of an hour?
Mr. Ferguson said, no, Your Honor.
The court said, you're ready with your first witness?
Mr. Ferguson said, yes, Your Honor.
Mr. Kamraju said, not from the defense, Your Honor.
The court said, all righty.
Luncheon recess. Continued on next page. Afternoon session 12:10 p.m. At sidebar.
The court said, I have a note from juror number 192. I don't remember his number, his actual number on the jury.
Mr. Kamraju said, it makes sense that he's an alternate.
Mr. Barkan said, 192 is alternate 5, Your Honor.
The court said, okay. Alternate 5. To the Honorable A. Torres, I am profoundly disappointed that my excuse for dismissal wasn't granted. My request began with I am a working single father. My child will have field trips, Father's Day, tea ceremony, and graduation, and I will now not be able to attend. When school ends on June 18th, I will not be able to take her to camp. My family is far away and not able to assist regularly. I am a widower. My wife passed away in childbirth, so being able to something my child is very important. I've just learned about the need to gather at a location at an agreed upon time. I dropped my child off at 8 a.m. Any adjustments brought in will cost me, my family and job gravely. not to mention thousands of dollars. I did not detail my work position and how I am required to be at my job. I thought my reasonable request based on my home and living situation would have been sufficient. To the attorneys, I appreciate the confidence you have in my selection. You have royally screwed me over. Juror number 192.
Ms. Strofa said, he's the gentleman who served on Judge McMahon's jury. I think he said that when he was being voir dired.
The court said, what would you like me to do?
Ms. Strofa said, I say we let him go. We have 6. We can live with 5.
Mr. Finkel said, so, Your Honor, the government is fine with 5 alternates. However, we defer to the court on the appropriateness on how to deliver the message. And the government's concern would be sending a message to the rest of the jury that merely sending a letter to the court would allow them to be excused from service. The government has no objection to proceeding with 5 alternates, and just ask the court to use its discretion and its experience on how to the timing of how to deliver the message.
The court said, so I am also told that the jurors are not pleased with the arrangement that they meet at a pickup point and be taken by car to the courthouse, which I think is acceptable.
Mr. Kamraju said, fine with us, Your Honor.
The court said, so this juror, alternate number 5, does not know about that offered alternative yet. I could always bring him in and ask him if that change would make it acceptable to him, see what he says.
Ms. Strofa said, we leave it up to the court, if the court wants to ask him. But he seems royally, as he puts it, pissed off. So my inclination would be to let him go. But perhaps the court could consider if we just let him sit through the day, and then we let him know just not to come on Monday. And then assume that, either tell the jury that, this is the new pool and provide no explanation, so that they don't think somebody got away with something.
The court said, I definitely will have him sit through the day, and I will speak with him after we're finished for the day. Okay.
Mr. Finkel said, Your Honor, one application before we leave. Just that the location where the jurors are going to meet be sealed in public record for the reasons that the government stated in its motion, and that the location where the jurors are going to meet not be shared with the defendant.
The court said, I think that is totally appropriate.
Ms. Strofa said, we don't even know where they were going to meet, so we have nothing to share.
The court said, okay, so those items will be sealed.
Mr. Finkel said, thank you, Your Honor.
Continued on next page.